Smith versus Allwright. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Smith versus Allwright, an opinion of the United States Supreme Court. Decided on April 3, 1944. Please note, this is a reading of the opinion of the court only. This reading does not include Justice Roberts' dissent. For ease of listening, this reading omits footnotes and legal citations found within the text of the court's opinion. Mr. Justice Reed delivered the opinion of the court. This writ of certiorari brings here for review a claim for damages in the sum of $5,000 on the part of petitioner, a Negro citizen of the 48th Precinct of Harris County, Texas, for the refusal of respondents' election and associate election judges, respectively, of that precinct, to give petitioner a ballot or to permit him to cast a ballot in the primary election of July 27, 1940, for the nomination of Democratic candidates for the United States Senate and House of Representatives and governor and other state officers. The refusal is alleged to have been solely because of the race and color of the proposed voter. The actions of respondents are said to violate Sections 31 and 43 of Title 8 of the United States Code, in that petitioner was deprived of rights secured by Sections 2 and 4 of Article 1 and the 14th, 15th, and 17th Amendments to the United States Constitution. The suit was filed in the District Court of the United States for the Southern District of Texas, which had jurisdiction under Judicial Code Section 24, subsection 14. The District Court denied the relief sought, and the Circuit Court of Appeals quite properly affirmed its action on the authority of Grovey v. Townsend. We granted the petition for certiorari to resolve a claimed inconsistency between the decision in the Grovey case and that of United States v. Classic. The state of Texas, by its constitution and statutes, provides that every person, if certain other requirements are met which are not here in issue, qualified by residence in the district or county, shall be deemed a qualified elector. Primary elections for United States senators, congressmen, and state officers are provided for by Chapters 12 and 13 of the statutes. Under these chapters, the Democratic Party was required to hold the primary, which was the occasion of the alleged wrong to petitioner. A summary of the state statutes regulating primaries appears in the footnote. These nominations are to be made by the qualified voters of the party. The Democratic Party of Texas is held by the Supreme Court of that state to be a voluntary association, protected by Section 27 of the Bill of Rights, Article 1, Constitution of Texas, from interference by the state, except that, in the interest of fair methods and a fair expression by their members of their preferences in the selection of their nominees, the state may regulate such elections by proper laws. That court stated further, since the right to organize and maintain a political party is one guaranteed by the Bill of Rights of this state, it necessarily follows that every privilege essential or reasonably appropriate to the exercise of that right is likewise guaranteed, including, of course, the privilege of determining the policies of the party and its membership. Without the privilege of determining the policy of political association and its membership, the right to organize such an association would be a mere mockery. We think these rights, that is, the right to determine the membership of a political party and to determine its policies, of necessity, are to be exercised by the state convention of such party and cannot, under any circumstances, be conferred upon a state or governmental agency. The Democratic Party on May 24, 1932, in a state convention, adopted the following resolution, which has not since been amended, abrogated, annulled, or avoided. Be it resolved that all white citizens of the state of Texas who are qualified to vote under the Constitution and laws of the state shall be eligible to membership in the Democratic Party and, as such, entitled to participate in its deliberations. It was by virtue of this resolution that the respondents refused to permit the petitioner to vote. Texas is free to conduct her elections and limit her electorate as she may deem wise, save only as her action may be affected by the prohibitions of the United States Constitution or in conflict with powers delegated to and exercised by the national government. The 14th Amendment forbids a state from making or enforcing any law which abridges the privileges or immunities of citizens of the United States, and the 15th Amendment specifically interdicts any denial or abridgment by a state of the right of citizens to vote on account of color. Respondents appeared in the District Court and the Circuit Court of Appeals and defended on the ground that the Democratic Party of Texas is a voluntary organization, with members banded together for the purpose of selecting individuals of the group representing the common political beliefs as candidates in the general election. As such a voluntary organization, it was claimed, the Democratic Party is free to select its own membership and limit to whites participation in the party primary. Such action, the answer asserted, does not violate the 14th, 15th, or 17th Amendment, as officers of government cannot be chosen at primaries, and the amendments are applicable only to general elections where governmental officers are actually elected. Primaries, it is said, are political party affairs, handled by party, not governmental officers. No appearance for respondents is made in this court. Arguments presented here by the Attorney General of Texas and the Chairman of the State Democratic Executive Committee of Texas, as amici curiae, urged substantially the same grounds as those advanced by the respondents. The right of a Negro to vote in the Texas primary has been considered heretofore by this court. The first case was Nixon versus Herndon. At that time, 1924, the Texas statute afterwards declared, "In no event shall a Negro be eligible to participate in a Democratic Party primary election in the state of Texas." Nixon was refused the right to vote in a Democratic primary and brought a suit for damages against the election officers. It was urged to this court that the denial of the franchise violated his constitutional rights under the 14th and 15th Amendments. Without consideration of the 15th, this court held that the action of Texas in denying the ballot to Negroes by statute was in violation of the Equal Protection Clause of the 14th Amendment and reversed the dismissal of the suit. The legislature of Texas reenacted the article, but gave the state executive committee of a party the power to prescribe the qualifications of its members for voting or other participation. This article remains in the statutes. The state executive committee of the Democratic Party adopted a resolution that white Democrats, and none other, might participate in the primaries of that party. Nixon was refused again the privilege of voting in a primary, and again brought suit for damages by virtue of Section 31, Title 8 of the United States Code. This court again reversed the dismissal of the suit for the reason that the committee action was deemed to be state action and invalid as discriminatory under the 14th Amendment. The test was said to be whether the committee operated as representative of the state in the discharge of the state's authority. The question of the inherent power of a political party in Texas, without restraint by any law to determine its own membership, was left open. In Grovey versus Townsend, this court had before it another suit for damages for the refusal in a primary of a county clerk, a Texas officer with only public functions to perform, to furnish petitioner, a Negro, an absentee ballot. The refusal was solely on the ground of race. This case differed from Nixon versus Condon in that a state convention of the Democratic Party had passed the resolution of May 24, 1932, hereinbefore quoted. It was decided that the determination by the state convention of the membership of the Democratic Party made a significant change from a determination by the executive committee. The former was party action, voluntary in character. The latter, as had been held in the Condon case, was action by authority of the state. The managers of the primary election were therefore declared not to be state officials in such sense that their action was state action. A state convention of a party was said not to be an organ of the state. This court went on to announce that to deny a vote in a primary was a mere refusal of party membership with which the state need have no concern, while for a state to deny a vote in a general election on the ground of race or color violated the Constitution. Consequently, there was found no ground for holding that the county clerk's refusal of a ballot because of racial ineligibility for party membership denied the petitioner any right under the 14th or 15th Amendments. Since Grovey v. Townsend and prior to the present suit, no case from Texas involving primary elections has been before this court. We did decide, however, United States v. Classic. We there held that Section 4 of Article 1 of the Constitution authorized Congress to regulate primary as well as general elections, where the primary is by law made an integral part of the election machinery. Consequently, in the Classic case, we upheld the applicability to frauds in a Louisiana primary of Sections 19 and 20 of the Criminal Code. Thereby, corrupt acts of election officers were subjected to congressional sanctions because that body had power to protect rights of federal suffrage secured by the Constitution in primary as in general elections. This decision depended, too, on the determination that under the Louisiana statutes, the primary was a part of the procedure for choice of federal officials. By this decision, the doubt as to whether or not such primaries were a part of elections subject to federal control, which had remained unanswered since Newberry v. United States, was erased. The Nixon cases were decided under the Equal Protection Clause of the 14th Amendment without a determination of the status of the primary as a part of the electoral process. The exclusion of Negroes from the primaries by action of the state was held invalid under that amendment. The fusing by the Classic case of the primary and general elections into a single instrumentality for choice of officers has a definite bearing on the permissibility under the Constitution of excluding Negroes from primaries. This is not to say that the Classic case cuts directly into the rationale of Grovey v. Townsend. This latter case was not mentioned in the opinion. Classic bears upon Grovey v. Townsend not because exclusion of Negroes from primaries is any more or less state action by reason of the unitary character of the electoral process, but because the recognition of the place of the primary in the electoral scheme makes clear that state delegation to a party of the power to fix the qualifications of primary elections is delegation of a state function that may make the party's action the action of the state. When Grovey v. Townsend was written, the court looked upon the denial of a vote in a primary as a mere refusal by a party of party membership. As the Louisiana statutes for holding primaries are similar to those of Texas, our ruling in Classic as to the unitary character of the electoral process calls for a re-examination as to whether or not the exclusion of Negroes from a Texas party primary was state action. The statutes of Texas relating to primaries and the resolution of the Democratic Party of Texas extending the privileges of membership to white citizens only are the same in substance and effect today as they were when Grovey v. Townsend was decided by a unanimous court. The question as to whether the exclusionary action of the party was the action of the state persists as the determinative factor. In again entering upon consideration of the inference to be drawn as to state action from a substantially similar factual situation, it should be noted that Grovey v. Townsend upheld exclusion of Negroes from primaries through the denial of party membership by a party convention. A few years before, this court refused approval of exclusion by the state executive committee of the party. A different result was reached on the theory that the committee action was state authorized and the convention action was unfettered by statutory control. Such a variation in the result from so slight a change in form influences us to consider anew the legal validity of the distinction which has resulted in barring Negroes from participating in the nominations of candidates of the Democratic Party in Texas. Other precedents of this court forbid the abridgment of the right to vote. It may now be taken as a postulate that the right to vote in such a primary for the nomination of candidates without discrimination by the state, like the right to vote in a general election, is a right secured by the Constitution. By the terms of the 15th Amendment, that right may not be abridged by any state on account of race. Under our Constitution, the great privilege of the ballot may not be denied a man by the state because of his color. We are thus brought to an examination of the qualifications for Democratic primary electors in Texas to determine whether state action or private action has excluded Negroes from participation. Despite Texas's decision that the exclusion is produced by private or party action, federal courts must for themselves appraise the facts leading to that conclusion. It is only by the performance of this obligation that a final and uniform interpretation can be given to the Constitution, the supreme law of the land. Texas requires electors in a primary to pay a poll tax. Every person who does so pay, and who has the qualifications of age and residence, is an acceptable voter for the primary, as appears above in the summary of the statutory provisions set out in Note 6. Texas requires by the law the election of the county officers of a party. These compose the County Executive Committee. The county chairmen so selected are members of the District Executive Committee and choose the chairman for the district. Precinct primary election officers are named by the County Executive Committee. Statutes provide for the election by the voters of precinct delegates to the county convention of a party and the selection of delegates to the district and state conventions by the county convention. The state convention selects the State Executive Committee. No convention may place in platform or resolution any demand for specific legislation without endorsement of such legislation by the voters in a primary. Texas thus directs the selection of all party officers. Primary elections are conducted by the party under state statutory authority. The County Executive Committee selects precinct election officials, and the county, district, or state executive committees, respectively, canvass the returns. These party committees, or the state convention, certify the party's candidates to the appropriate officers for inclusion on the official ballot for the general election. No name which has not been so certified may appear upon the ballot for the general election as a candidate of a political party. No other name may be printed on the ballot which has not been placed in nomination by qualified voters who must take oath that they did not participate in a primary for the selection of a candidate for the office for which the nomination is made. The state courts are given exclusive original jurisdiction of contested elections and of mandamus proceedings to compel party officers to perform their statutory duties. We think that the statutory system for the selection of party nominees for inclusion on the general election ballot makes the party which is required to follow these legislative directions an agency of the state insofar as it determines the participants in a primary election. The party takes its character as a state agency from the duties imposed upon it by state statutes. The duties do not become matters of private law because they are performed by a political party. The plan of the Texas primary follows substantially that of Louisiana, with the exception that in Louisiana the state pays the cost of the primary, while Texas assesses the cost against candidates. In numerous instances, the Texas statutes fix or limit the fee to be charged. Whether paid directly by the state or through state requirements, it is state action which compels. When primaries become a part of the machinery for choosing officials, state and national as they have here, the same tests to determine the character of discrimination or abridgment should be applied to the primary as are applied to the general election. If the state requires a certain electoral procedure, prescribes a general election ballot made up of party nominees so chosen, and limits the choice of the electorate in general elections for state offices, practically speaking, to those whose names appear on such a ballot, it endorses, adopts, and enforces the discrimination against Negroes practiced by a party entrusted by Texas law with the determination of the qualifications of participants in the primary. This is state action within the meaning of the 15th Amendment. The United States is a constitutional democracy. Its organic law grants to all citizens a right to participate in the choice of elected officials without restriction by any state because of race. This grant to the people of the opportunity for choice is not to be nullified by a state through casting its electoral process in a form which permits a private organization to practice racial discrimination in the election. Constitutional rights would be of little value if they could be thus indirectly denied. The privilege of membership in a party may be, as this court said in Grovey v. Townsend, no concern of a state. But when, as here, that privilege is also the essential qualification for voting in a primary to select nominees for a general election, the state makes the action of the party the action of the state. In reaching this conclusion, we are not unmindful of the desirability of continuity of decision in constitutional questions. However, when convinced of former error, this court has never felt constrained to follow precedent. In constitutional questions where correction depends upon amendment and not upon legislative action, this court throughout its history has freely exercised its power to re-examine the basis of its constitutional decisions. This has long been accepted practice, and this practice has continued to this day. This is particularly true when the decision believed erroneous is the application of a constitutional principle rather than an interpretation of the Constitution to extract the principle itself. Here we are applying, contrary to the recent decision in Grovey v. Townsend, the well-established principle of the 15th Amendment, forbidding the abridgment by a state of a citizen's right to vote. Grovey v. Townsend is overruled. Judgment reversed. End of Smith v. Allwright, an opinion of the United States Supreme Court.